the APRA is 2 years in the making. Since that original legislation was filed last year, many hours have been committed to talking with stakeholders to hear their concerns about the bill and also making additional enhancements to it. The updates we are recommending would limit the cost that can be charged for releasing public records, require an explanation when public bodies attempt to withhold records, and expand the kinds of records that are subject to the law, in keeping with advances in technology that have happened over the last decade plus. These are all goals that we feel should be embraced by anyone who supports transparency, which should be all of us, regardless of our political leanings. Now, to get us started, I'd like to introduce the lead sponsor of the legislation in the Senate, Senator Lou DePalma.
You can save your applause until we pass the bill. So we'll wait to. I do want to thank my sponsor on the House side, my colleague, Chairwoman Patricia Serpa on the House, who is sponsoring this in the House side. So thank you for the intro, folks. Thanks for being here. As he indicated, this does go back almost 2 years. My initial call to, where's Nancy? Linda, rather. Linda's there. Linda Levin and I had a conversation along with Justin Silverman back August of 2022, I think, roughly. Or even before that, probably July. And I said back then, we need to address our Access to Public Records Act. I want to give credit to the late Senator Michael Lenahan. So those who know about access to public records, access to open meetings, separation of powers, that name will be very familiar to it. If you don't, I'd ask you to go back and look. He passed away in the early 2010s, but his legislation was the legislation that brought us to where we are now, well over a decade ago. Many things have changed since then, but it's been the work in the meeting we had, myself and Linda, Justin, and I said, here's what we need to do. Can you help? They said, absolutely. So as was said, it's the Access Rhode Island, New England First Amendment Coalition, Common Cause, ACLU, League of Women Voters, Press Corps. The six folks were instrumental in getting us to where we are. Let's just talk a little bit about the rest of the process subsequent to the hearing we had, I believe it was April last year. Subsequent to that, and the only thing I know is to take the feedback that we received, and we received back from Department of Administration, Department of Revenue, Governor's Office, Police Chiefs Association, the Attorney General. We had a meeting with them to work through some of theirs, also talk with Department of Corrections. Many folks had feedback with regards to how much they liked the bill. Not really, nobody did. Much feedback, though, with regards to the changes that were needed. And you'll hear from folks coming up after us about those changes. I can enumerate those now. We're not going to do that today. Today is about where we are going forward and why it's the case of moving forward. And we're familiar with some recent events, some a couple weeks ago, with regards to access to information and how various folks were treated or not treated or whatever with regards to information. Why was it, I'll say, personal and important to me? And Rep. Serpa, at one point in time, I chaired the Senate Committee on Government Rules, Ethics, and Oversight. Chairwoman Serpa chairs Oversight and has for many, I want to say many years, many sessions, but she had many sessions here in the General Assembly. I saw firsthand with regards to the access for information, the availability of information, and what I needed to go through, and what you folks, I know some of you out there, go through each and every day. Even to some of the stuff I went to the Attorney General because of being denied information that I was looking for. Understand and feel your pain front and center. But it goes back to the public can only trust government when they know what's going on. So there's a quote that I want to read to you, and most folks, I'm going to ask you who wrote this in a minute. In 1891, a person who later served as judge of the U.S. Supreme Court wrote, "If the broad light of day could be let in upon man's actions," I should have said men and women, but back then it was men's actions, "it would purify them as the sun disinfects." Justice Brandeis. Common phrase, the sun is the best disinfectant. What does that mean? Transparency. We need to become more transparent. As you'll see from the folks that are coming after us, they're going to tell you some of the whys. There are many whys of why this is important now, least of which is technological changes over the last 10 years and the experiences these folks have had and you have had over the last 10 years with the challenges in the access open information. In some regards, we, Rhode Island, have a long way to go, a long way to go. I think the legislation we have before us brings us closer to where we need to get to go. Not completely there. Some states do it phenomenally well. Rhode Island, we're going to move this forward. We're only going to move it forward with your help. So I want to turn it over to my comrade in arms here, Chairwoman Serpa.
Thank you, Senator. I beg your patience with me. I still have a lot to learn about this bill. It's a new issue for me. I understand that a couple of my predecessors had a crack at it, but were unsuccessful. I'm a former teacher, and I know that people learn best by stories. Literally, on my way here today, the story hit home with me. I represent Coventry and West Warwick. A Coventry resident called me. Parents in Coventry are upset with the school superintendent because he wants to consolidate some schools. And apparently, and it all bears to this bill, and apparently he's done it without any parent input, any teacher input. He just wants to do it. He has no numbers, no plan. It's just, we're going to do this. So to fast forward and make a long story short, parents went to the school committee and asked for the data that led him to make this decision. The school committee, as it was reported to me by this parent, the school committee authorized the business office in the town of Coventry to release this information and to charge the parents $600 for the information that they've already paid for because they pay taxes. And it's public information. It's budgetary in terms of what this General Assembly allocates to the town of Coventry. It's some budgetary information contained within the town of Coventry, but they wanted to charge, they authorized the charging of the parents $600. It's absolutely insane. There's no professional way to say it, and these parents shouldn't be subjected to it. So in a subsequent phone call, I think the superintendent may be rethinking that decision. And certainly, when I get home tonight, I am going to make my phone calls and ask where that $600 fee stands. So please bear with me. As I said, I'm new to the issue. I expect my expert, Senator DePalma, will certainly tutor me along the way. So I invite your help, I invite your input, and if I can be of any help to you, or if you can be of help to me, I should have said it that way, I welcome your input. So thank you very much, everyone.
Thank you, Chair. There are a few senators I want to recognize here. There are, I think, 6 of them that were here. Senator Valverde is here, Senator Ujafusa, Senator Dela Cruz, Senator Rogers, Senator Acosta, and Senator LaMountain. I know there's been several reps here as well, but back to you, Mike.
Thank you. I'd like to bring up our next speaker now is General Manager of the East Bay Media Group, Scott Pickering.
Thank you, Mike. Just a brief preview or overview of what I do. I run a group of newspapers and a website. We publish weekly newspapers from East Providence down to Little Compton, Rhode Island. And so a lot of the issues I'm going to touch on are sort of small town stuff. The Washington Bridge affects hundreds of thousands of people every day, and some of the stuff we focus on might affect 100 people a day. But in my mind, in terms of the way government operates, they're equally important, and the protections that the public has are equally important. One thing that the bill that we're submitting does is, in my mind, it really modernizes the legislation in Rhode Island to reflect where we are today in 2024 with modern technology. So, when we think of public records, we think of like paper and manila folders and, stuff shoved into a filing cabinet. Well, the world has changed, and records today are, in many cases, electronic, and they're PDFs, and they're stored, and they're emailed, and they're easily transmitted. And our law doesn't really reflect all the digitization and all the electronic storage that has evolved in government record keeping. So here's a few examples of what the bill would do and how it would apply in real life. One of the changes we would make would be make it mandatory that when a public body is discussing something that's reflected in a public record, that the record should be available at the public meeting. So if they're discussing a consultant's report, a draft policy, a new description, a building plan, whatever it might be, that those things are available to the public at the same time it's being discussed by the board. I'm not going to pick on. I'm going to pick on a little bit some of the bodies out there, but not in a way to call them out. It's just an example of what happens. Take the town of Portsmouth, one of the towns we cover. The Portsmouth Town Council posts an agenda before every meeting that has all the backup materials shared, digital. You can link. You can open up all the PDFs. You can open up all the documents. In the exact same town, the Portsmouth School Committee does not do the same thing, does not have the same materials available, does not have the same linking in PDFs. And they're not doing anything wrong per state law. They're abiding by the public records laws. But the difference is that at a recent meeting, they were discussing a new student survey on substance use. They were discussing a new policy on student substance use. They were discussing a new job description for an administrator in the district. And they were voting on these things, and none of that material was available to the public at the time it was being discussed. So that's one thing we'd like to improve, is set the standard that, yes, there are many, many government bodies that are following best practices, but they're not, and they're not required to. So that would be one example where we could improve things. Another thing we would change in the bill would be to make it clear that email communication between government officials or the use of government officials' email in their officials' duties is in fact public. As of right now, that is not subject to disclosure, and that would be another thing you could see where sort of the world has moved. How much communication is done in written memos filed in file cabinets and how much is done by email. An example, in the town of Tiverton, there was a private business owner who's in a dispute with the town over a number of issues, use of property, permitting and such. He used an attorney to file a request for all the email communications around his case. What was released was an enormous volume of information, some of which was very revealing about decisions that were being made, biases that you could reflect in the language in which they talked about this business owner. And the attorney told me on background that he doubts whether the average citizen would have been able to get the same release of information. It was because he's an attorney representing a client who went in to talk to another attorney representing the town, and they have a good relationship, and he was able to get it. He's skeptical about whether the average citizen would be able to get the same thing. And again, this is really valuable information that reveals important decisions that were being made affecting him. I got two other quick ones I'll go through very quickly. One of the areas we're talking about is the use of body-worn cameras by police officers. Again, this is a new technology. This did not exist the last time this bill was amended. This is an effort to update the law to reflect what is currently happening. When we introduced this last year, the Police Chiefs Association objected to a number of things. This was one of the areas about we would ask to require that in a use of force incident, that police body camera footage be turned over upon request within 30 days, and there could be an application to extend that if necessary. And some of the reasons they explained to us was that this was burdensome, the amount of labor and time it took to review footage, to redact it if necessary, and that this would be an undue burden on their resources. Just one anecdote from one situation, but not long ago in the fall, there was a use of force incident in the Bristol Police, actually in the Bristol Police parking lot. Someone who was acting in a dangerous way, threatening two women and a police officer, was shot. And in this case, the footage was released in less than 3 business days, and not only was it released, it was, and I should add that the footage, I think any reasonable person would conclude that the officer was acting completely within his rights and properly in this situation. He was threatened, and I think you would conclude that the use of force was justified. And in this case, lo and behold, the footage came out in less than 3 business days, and not only did it come out, but it was annotated with arrows pointing to every member in the video, showing who they were, who the participants were, their names, and what role they played. And I thought, well, that, in this case, it seemed like they were able to do it It happened pretty quickly, and so the request for a 30-day period of time to receive footage didn't seem to be too onerous in that case. And the last one, and this one's kind of personal to me because it's one of the more frustrating experiences I've ever had as a journalist pursuing records. There was a case in the town of Barrington involving the school department where a middle school student was suspended from school for a conversation he had in the school cafeteria. And it was a conversation with his friends about a school shooting. Essentially, he was suspended from school. His family objected. They were denied. They kept fighting. The ACLU got involved. Eventually, with the ACLU's help, they were able to win the case and say that the student shouldn't have. That the school district mishandled the suspension. The school district appealed, and it went to another level. The school district lost. The school district appealed again and went to another level. They lost. The school district appealed again. It went to another level, and they lost. After 2 years, we started asking, what is this case costing the taxpayers of Barrington? And we were unable to obtain any information about the legal cost of this case because it was not a public record maintained by the school department, and it was subject to the attorney-client privilege. And to me, that was a really big offense to sort of the taxpayers and the basic access to public information, that we couldn't find out what is this case that the school department was appealing through 4 layers of government. What is this costing to to defend that a 8th grader should have been kicked out of school for a period of time? And we never were able to get it. One of the things in this bill would make it clear that records subject to attorney-client privilege are, in fact, able to be kept from the public, but not all records between a public body and their attorney. And that would have solved that situation had that been in place at the time. I'm done. Thank you very much.
Thank you, Scott. Now I'd like to introduce Steve Brown, Executive Director of the Rhode Island affiliate of the ACLU.
Thank you, Mike. I've been asked to address the bill as it relates to police records, which is an extremely important issue. Well, you know, there's a lot of discussion this session of the legislature about reforming the Law Enforcement Officer Bill of Rights, and the idea behind that is trying to promote greater transparency and accountability with police. But the fact of the matter is that Leobor affects only a very small number of officers and officer misconduct. The real issue is whether records are available under the state's Access to Public Records law, which is the law that really addresses that type of scrutiny and transparency. And I'm very pleased that this bill in a number of ways tries to address and make better accessible certain police records. And I just want to give a few very specific examples. One has to do with, related to Leobor, other findings of police misconduct. As a result of some recent Attorney General opinions, there has been a conclusion that APRA currently does not allow the public access to all final reports of investigations of police misconduct, even with identifying information of the officers redacted. That is inexcusable. I mean, and there are many states where there are databases, public databases, that not only include all the information about misconduct complaints, but the names of the officers involved. And here in Rhode Island, we can't even access redacted information about the findings of police misconduct. This bill would change that and make it clear that the public has access to these final investigatory reports, even with the names of individuals redacted. Another important aspect relating to police records has to do with incident reports that are not followed by arrests. The law is fairly clear, although it often gets ignored, that arrest reports themselves are public records under APRA. But a lot of important incidents take place where arrest doesn't occur, and those are deemed presumptively non-disclosable. And this bill would change that and say there's no presumption that simply because a police incident did not result in arrest, there's a presumption that the public does not have access to it. The final one I'll mention, which is one that Scott actually talked to, which we also think is extremely important, has to do with this new technology of body-worn camera footage. The whole idea behind equipping officers with this new technology was to promote transparency, to promote accountability, and it seems to us that when there's a serious use of force incident, it's absolutely crucial that the public have access to that camera footage in a reasonable period of time. And this bill would ensure that that happens without in any way, we believe, burdening police departments in giving the public access to that. So we're very hopeful that this will be the year, after more than a decade, of finally doing some great reform of the open records law and making the public a lot more easily available to see what their government is doing. Thank you.
Thank you, Steve. Next, I'd like to introduce John Marion, Executive Director of Common Cause of Rhode Island.
Sorry. Thank you for joining us today. Public records aren't public if the public can't access them. That's why this bill we're proposing makes a number of changes that will make it easier for the public to get access to records and strengthen penalties for government agencies who incorrectly withhold them. Currently, if a person requests a record, they can be charged 15 cents per page for duplication and $15 per hour for search and retrieval. Under the proposed bill, the requester is going to be given 1 hour, an additional hour of search for free, and the per page cost would be reduced from 15 to 5 cents. This is one of the ways that we're trying to make records more accessible to the average Rhode Islander, as Representative Serpa talked about earlier. The bill also lowers costs in a couple of additional ways. For the first time, it will not allow the government to charge for redacting information for the first 2 hours that they do that. It doesn't make sense to be charged with information you can't even get access to. So secondly, it prohibits charging when the requester is denied any access to any record by an agency. Again, it's farcical to be charged money to not get something you requested. Under the current law, if a member of the public who requests a record is charged and they believe they shouldn't be because the request is in the public interest, right now they have to go to the Superior Court and ask for a public interest exemption. Of course, going to Superior Court requires money because you have to hire legal representation, which sort of defeats the whole point of asking for the fee waiver. So like the Federal Freedom of Information Act, the bill allows the requester to appeal that public interest exemption to the agency that provides the records, and it requires the agency to consider the public interest. On the flip side of making it easier for the public, we're trying to strengthen enforcement when the government incorrectly withholds records. The bill increases fines for all types of violations of the public records law. For the most egregious offense, it allows the court to impose daily fines when the violation is knowing and willful. Finally, it funnels any fines assessed by the Attorney General or the courts to a restricted receipt account that will assist municipalities with APRA compliance. You know, one of the crazy things about the current law is that the government is paying a fine to itself, right? So if the government withholds a record and has to pay a fine, it's just going back into the general treasury. In this case, we're going to put it to good use to work on APRA compliance. Last year, as you heard, we put forward a bill that had much steeper increases in fines and wouldn't allow the government to charge at all for redaction, among other things. This year's bill, in numerous ways, as you heard, is the result of conversations with a number of stakeholders. Sid from the Police Chiefs Association is here, one of the many meetings we had. We didn't make every change that was asked of us, but we made quite a few. So I want to thank the government officials who were willing to sit down with us and meet, and Senator DePalma for leading the way in that. And that is Common Cause's take on the proposed bill. Thanks.
Thanks, John. And next, Liza Birkin is lead organizer from the Providence Streets Coalition. Liza.
Hi, everyone. So grateful to be here today supporting this bill. My name is Liza Birkin. I'm the lead organizer of the Providence Streets Coalition, which is an alliance of 42 organizations, businesses, neighborhood associations, and schools in Providence that support safer streets, more transportation choices, and policies that advance mobility justice, like saving RIPTA, but that's not what I'm here to talk about today. So I'm going to back up about 5 or 6 years to when I was a graduate student studying transportation planning, and then a private consultant in Massachusetts. I would work often with the Massachusetts DOT crash portal, which folks have been talking about new innovations in technology. Spreadsheets and GIS mapping has been around for a long time, so this is not that. This is about transparency. So I would work with the Massachusetts Data Crash Portal in my work as a consultant, making safety plans for municipalities around Massachusetts. It's a website. You just click, town, crash type, left lane crash, right lane crash, time of day, what kind of if there was an animal involved, you can filter out this spreadsheet and get the data that you're looking for very specifically within seconds for the entire state of Massachusetts. And it was incredibly helpful. I was able to do my work quickly, both as a researcher and as someone working for municipalities to create their transportation plans. So I came home to Rhode Island and founded the Streets Coalition, and very quickly realized that Rhode Island didn't have this resource. And went to the statewide Traffic Safety Coalition meeting and asked for it. And this was over COVID, and we were on a path to creating such a resource. RIDOT showed it in a meeting, and it looked very similar to the Massachusetts website. And then, all of a sudden, a few months passed, and it was shut down. RIDOT officials stopped communicating with me, and I had no idea why. I was very frustrated, but ultimately let the issue lie. Fast forward a few years later, and suddenly as the Streets Coalition grew and took on more capacity, we had a dedicated group of volunteers who were into mapping and data and IT work, and they wanted to make this happen. So we resurrected the idea. One of our volunteers, who is here in the room right now, APRA'd RIDOT for the crash data. They refused. We appealed to the Attorney General's office. Their office found that RIDOT did not violate the current APRA law, which is why we're here talking about it. But their ruling did say, we have not been presented with evidence that DOT was required by law to keep these records confidential, and the record before us contains evidence indicating that while DOT had discretion to withhold the requested information, it was not required to do so. We strongly encourage DOT to consider whether it may be in the public interest to disclose the requested information, which again is crash data de-identified. We're not looking for people's names. We're just looking for the locations and the causes of crashes. So we also APRA'd, at the same time we APRA'd RIDOT, we APRA'd the City of Providence. And their police department and planning department complied with our request, and we were able to build out all volunteer-led and interactive crash data portal for the City of Providence that analyzes more than 3,000 crashes involving pedestrians and cyclists over a period of 12 years, which is live on our website now. Anyone can use it. So when there is a crash and members of the press are wondering how many crashes happened at this intersection, in the past 12 years, you can go to our site, get that information very quickly. We believe that that should be available for the entire state. Around this time, when we put out our crash portal, the press took interest in this story. And Colleen Cronin, an incredibly talented reporter from EcoRI News, realized that while RIDOT would not share the crash data, she could APRA the APRAs for the crash data and put out a brilliant piece of reporting finding that RIDOT had denied 17 individuals from obtaining this data just since 2019. Almost all of them hoping to use it to evaluate or improve safety. Some of them were consultants, some of them were academics, and some were just regular people. RIDOT's assertion of privilege presupposes that the public has no role to play in utilizing crash data to help professionals or to make our roads safer. Our crash map demonstrates that community groups or academics can step in and assist with data when government agencies like smaller towns, municipalities may not have the capacity to do so. Public crash portals are now normative in other New England states such as Massachusetts, but also in the Deep South in Louisiana and the Midwest in Missouri. The idea that the public should have access is not a fringe position. Rhode Island is increasingly an outlier in this area. And it's not surprising given the culture of secrecy at the Department of Transportation that we're all pretty aware of this week. So while we disagree on the tactics, we believe that our stance with RIDOT that we're on the same side here to the extent that we see improving road safety as central to our mission. Community groups are trying to create these tools to do their job better, specifically to make infrastructure decisions with a more scientific grounding in the data. So this bill, of course, is all about increasing the transparency for the good of all Rhode Islanders, and I'm so grateful to be supporting it, and let there be light.
That wraps it up for our speakers. We do have some handouts if you haven't received them yet, but if anybody, open it up for questions for any of our speakers. Yes.
Sure. In terms of the spiritual nature of APRA, what you find often in Rhode Island, for everyone in this room can attest to this, is that there's administration, municipalities, school departments who use APRA to effectively deflect timely requests for information. They'll take full advantage of the extension. They'll wait even though a lot of this data can be just file print. It literally can be had in moments. What does this law do to address that? And is there any way to shorten, if you will, the primary, if you will, extension period?
I don't know if Senator DePalma, do you want to, I don't know if you heard the question.
What's the end of it, Pat?
Well, basically, you've got cities like Pawtucket, which will wait to the 29th day and the 18th hour to send something out for something that could have been easily file print using today's technology in a day or so.
I'm not certain this is going to change that behavior. I've experienced that. When I get to day 10, day 9 hours and 9 days and 11 hours into that, we want another 20 days. Another 20 business days, which means another month. So this doesn't do that. What I believe by doing this, by people responding quicker, and I think you're seeing some state agencies already putting stuff, making it available before somebody has to go ask for it, behavior is going to change, but this isn't going to do that. So,
When you proposed this bill last year, the governor's office opposed it, and in part, Claire Richards, the general counsel, said, you've got the proposal to release information that's in the public interest for free, but she said all requests for public records can be characterized as in the public interest because they come from the public, and public bodies should be in the business of determining whose request is in the public interest. That should be up to a court. What do you say to that?
The public that's asking for information should be given the information they're asked for, period. There's the pendulum swung back, I think, from when Senator Lanahan did this. We moved the needle, and I was here then, I'm glad to have known him, moved the needle to, in fact, the balancing test that was used with a recent trip by a couple of folks down to Philadelphia. That balancing test was used, and because of what was done back in 2012, we got access to that email. I think, Ed, with regards to what this legislation can do, is to ensure that when people ask for information, they're given the information. It's much made more easily accessible. Rather than having to ask for it, people know, oh, it's on the website. They put all procurement stuff there. As soon as it's done and ready available, it's there. We don't have to go ask somebody for, and then, as you said, Pat, 9 days, 11 hours into it, we're not going to give it to you today.
Can I follow up on the idea of what Liza said? She appealed to the agency for public interest exception, but the agency that was denied her then decides, well, it isn't in your public interest, so no, and they still don't get it, right? So they already asked for that, they get it. So how does this law change that?
In the case of the, Steve, if you want to come up, in the case of the accident data, that's explicitly in the law. We put in. Okay. By the way, if you need to have any questions for me, I do need to go to another press conference that started at 3:30 about a bill that's being introduced very soon. So thanks for being here, but I'll be around if you want to give me before session. Thank you.
Thanks. Just to very briefly respond to this public interest issue, there are a few responses to that. One is that many requests to public bodies are from commercial entities. They are clearly not directed in the public interest. That is one clear delineation that can be made right at the beginning. In addition, the standard that is being put in this bill is the standard that has been in the Federal Freedom of Information Act for half a century, that public agencies have had to comply with in terms of waiving and reducing fees and costs. So there's nothing unique, there's nothing special, there's nothing complicated about it. There's the individual who makes the request has to explain why they believe it's in the public interest, and if they are able to do so, then they should be entitled to those records at no cost, just as they are at the federal level.
I don't know who can address it, but you said you've spoken to a lot of the groups who've had interest in either preventing a change from happening or watering it down. With the governor's office specifically, have they provided any terms that they would agree to with any change, or they just no, no matter what?
Yeah, so I'll try to speak to that. Steve and Senator DePalma and I met with the governor's office over the summer. I think we found a little bit of common ground on a couple particular matters, but certainly, like the last example, they don't believe that government agencies should be put in that role, and we think government agencies should have to be put in that role. So, I can't off the top of my head say like which are the things where we started to see eye to eye on. I will say like a big issue for them, I recall, were the fines and sort of the ridiculousness of government paying itself fines. And as a result, we came up with the idea that it goes into a restricted receipt account that is used then for APRA compliance by municipalities. So, we took some of the feedback and we did try to incorporate it into the bill where we thought it was reasonable, but there are certainly, virtually everybody we met with just wanted us to eliminate all of their objections, and had we done that, there would be no bill to speak of.
Yes. Just very briefly to follow up on that, I also don't want to get into the specifics, but I can tell you there are 47 changes to the law in this bill. Some of them are very small, minor, clarifying. Some are major, what you've heard about today. I looked at the list, and of those 47, there are 21 of them had changes made from the original version based on the conversations that Senator DePalma organized with various government entities. So we did listen. As John said, I don't think the government agencies are still going to be happy with this, but we really did attempt to accommodate a lot of the concerns we felt were reasonable. But at the end of the day, the bottom line is this is a public's right to know, and while some public agencies may find it burdensome or difficult, it's their responsibility, it's their job to be accessible to the public.
Can I ask a clarifying question about the legislation? When I send in a APRA request, I'm often hit with a huge fee, like $2,000 or more. And what I'm told is it's the redaction cost, paying a lawyer to go through an set of emails, for instance, $15 a page, or one page every 15 minutes, right? So that's what they say plus. So then they base their fee on that to pay a lawyer $60. Now, if I find that one of my pieces has been rejected by that lawyer, this law seems to say they wouldn't be able to charge me for that. Well, that would be free for a lawyer to look at it and say no. But if a lawyer sits down and rejects everything but a couple of words per page, it seems like I would still get charged for that under this law because I would be getting part of the record. You see what I'm saying?
If the request was not in the public interest. I mean, keep in mind that there's this very broad attempt to reduce and eliminate fees when there are requests made that are really in the public interest to know.
And one other clarifying, sorry to interrupt.
Sorry.
Corporations include some of the organizations that people in this room work for. And so when you say business, like the business of doing news could be, so is that clarified in this bill as well? So I'm thinking like Boston Globe, for instance, they're a business and they're saying, hey, we want this. They might say that's not public interest because it goes right to their bottom line to sell paper.
No, again, there's lots of case law in this in the federal level. As I mentioned, this is based on the Federal Freedom of Information Act. Members of the media are routinely considered asking for requests in the public interest. When I talk about commercial entities, I really mean commercial entities trying to get commercial information from public bodies.
I have a question about, there are so many changes in this bill. If this were to pass, is there a learning curve for both the journalists and them to figure out what they're really able to give us?
Yeah, so I think that's a great question for people who couldn't hear. Is there a learning curve for the agencies and for journalists? And certainly there is, based on our 2012 experience. That bill didn't go into effect, I think, until September 1st. And one of the key things here is that the Attorney General holds that Open Government Summit every year, providing guidance to hundreds of people. That event has more than 500 people at it, about how to comply with the law. And we would expect the Attorney General in this instance would have to look at the new statute and provide additional guidance. Will it take time? Sure. So, in 2012, the balancing test was put in. There have been a series of precedents over the years. Some have, we've disagreed with, some we've agreed with, but we've started to settle into sort of an equilibrium where I think reporters know how to make that public interest appeal under the balancing test, and government agencies, have a series of decisions on which they can sort of make judgment calls. I think the same thing would happen with the fee waiver, right? I think there would be, requests for fee waivers, some accepted, some rejected, and over time we'd reach an equilibrium point where government would learn how to apply it within the bounds of how the Attorney General and the courts interpret it. So yeah, it's going to take some time.
And, APRA's been in the news for a specific reason the last few weeks because the records request for the bridge records, the Washington Bridge records. So could you address the idea of whether those requests from the media were in the public interest and the idea that the government couldn't decide whether they are, and what you think of the different charges?
Yeah, I think it's a perfect example of a request that's in the public interest. The biggest story in the state in the month of December was the Washington Bridge being closed down or limited. All the major media outlets in the state were all making, a very similar records request, and they were charged. You've seen the government back off on that when they realized how embarrassing it was to charge the government for that. On the differential amounts, the bill doesn't touch on that, but the bill does touch on something that we saw, and it wasn't mentioned earlier, which is, the government did do a couple of right things in providing the RIDOT emails. It told you what you didn't get in some instances, and they weren't necessarily required to enumerate what documents you didn't receive. The bill would require that. So if you're denied some records and given some records under the bill, you have to be told what specifically were you denied. And we think that's incredibly important because you can't really appeal a denial unless you know what you were denied. And under the current law, you really don't, there's very little insight into what you were denied.
The traffic accident data and the preferred license plate, that's new in this year's version of the bill. Can you talk about when that was added or when that was introduced into the conversation from last year to this year?
Yeah, so we, there's two instances in the bill where we really sort of target specific sets of records that have been denied. One Liza talked in great detail about, and that was basically after that EcoRI news reporting. The coalition sort of looked at that and said, we should put that in the bill and just try to get that information made public. And the same thing with the preferred license plates. So there's I think a pending appeal by the Providence Journal on that issue, but nonetheless we thought we would put that in the bill and kind of settle that once and for all.
I think these two incidents also demonstrate that this is an ongoing process. As you heard Senator DePalma say, we don't expect passage of this bill to solve all the problems that exist in terms of getting access to public records. There will be these incidents that crop up, denials that crop up that were not considered in the legislation or that are loopholes that will need to be fixed as time goes on. But we think that passage of this bill would go a long way towards addressing a lot of the issues that our organizations have seen over the past decade since the law was last reformed.
Yeah, I just want to jump in on one issue, because when you were talking about the role the attorney plays in releasing the information, it really resonated with me. In my 30 years of covering local governments, one thing that's really changed is the prevalence of solicitors and attorneys, and not to pick on the folks in the legal profession, but the prominence they play in the running of government agencies these days. You can't see a town council meeting or a school committee meeting without the attorney sitting there next to the board, and whoever's running the meeting, the chairperson, looks at them 100 times a meeting about meeting procedure, policy, how to handle issues. Any public records request these days, it seems like it's not the town clerk who's making the decision, it's the attorney. They are heavily involved in all of these decisions. The government agencies have in many regards passed that duty on to the legal representation, which is why when we talk about changing the law to make things more available, it's burdensome or it's a drain on resources, because they're having the attorneys do the bulk of the work. And it should be reasonable that the government, the keeper of the records, would know the law well enough to be able to make decisions on their own and not have to rely on legal counsel. And the ironic thing in that example I talked about in the Barrington School Department with the ongoing legal case, is that I knew that as I was appealing to try and get the information on the costs of that case, that the attorney was making the decision about whether I was going to get the cost of their legal services to the town of Barrington, because the administration of the school district was just a pass-through. Every decision was being made by the attorney about whether it should be released, and it was just being passed on to me. And so, you know, the training, as we were just talking about, the training and the understanding of the law and the ability to make their own decisions would go a long way to reducing the burden, on making these decisions and handling these records. And that's something that really, it would be nice if that culture changed in the government as well.
You want to wrap it up?
Sure. Thank you, everybody, for coming. And we're around for a little while if anybody has any follow-up questions. Thank you.